International law. International law, unlike national laws, derives not from actions of a legislative branch or other central authority, but from tradition and agreements signed by states. It also differs in the difficulty of enforcement, which depends not on the power and authority of central government but on reciprocity, collective action, and international norms. Definition of international law. International law is a set of rules and principles governing the relations and conduct of sovereign states with each other, as well as with international organizations and individuals. Issues that fall under international law include trade, human rights, diplomacy, environmental preservation, and war crimes. Sources of international law. Laws within states come from central authorities, legislatures, or dictators. Because states are sovereign and recognize no central authority, international law rests on a different basis. The declarations of the UN General Assembly are not laws, and most do not bind the members. The Security Council can compel certain actions by states, but these are commands rather than laws. They are specific to a situation. No body of international law has been passed by a national legislative body. 4 sources of international law are recognized: treaties, custom, general principles of law such as equity, and legal scholarship, including past judicial decisions. Primarily, treaties and other written conventions signed by states are the most important source. International treaties now fill more than 1,000 thick volumes, with tens of thousands of individual agreements. A principle in international law states that treaties, once signed and ratified, must be observed. States violate the terms of treaties they have signed only if the matter is very important or the penalties for such a violation seem very small. In the United States, treaties duly ratified by the Senate are considered the highest law of the land, equal with acts passed by Congress. Treaties and other international obligations such as debts are binding on successor governments whether the new government takes power through an election, a coup, or a revolution. For example, after the revolutions in Eastern Europe around 1990, newly democratic governments were held responsible for debts incurred by their communist predecessors. Even when the Soviet Union broke up, Russia as the successor state had to guarantee that Soviet debts would be paid and Soviet treaties honored. Although revolution does not free a state from its obligations, some treaties have built-in escape clauses that let states legally withdraw from them, after giving due notice, without violating international law. For example, the United States in 2001 invoked the 6th-month opt-out provision of the ABM Treaty. Because of the universal commitment by all states to respect certain basic principles of international law, the UN Charter is one of the world's most important treaties. Its implications are broad and far-reaching, in contrast to more specific treaties such as a fishery management agreement. However, the specialized agreements are usually easier to interpret and more enforceable than broad treaties such as the Charter. Another key treaty in international law is the 1949 Geneva Conventions, expanding an 1864 convention, defining the laws of war regarding the protection of civilians and prisoners, among related issues. Custom is the second major source of international law. If states behave toward each other in a certain way for long enough, their behavior may become generally accepted practice with the status of law. Western international law, though not Islamic law, tends to be positivist in this regard. It draws on actual customs, the practical realities of self-interest, and the need for consent rather than on an abstract concept of divine or natural law. General principles of law also serve as a source of international law. Actions such as theft and assault recognized in most national legal systems as crimes tend to have the same meaning in an international context. Iraq's invasion of Kuwait was illegal under treaties signed by Iraq, including the UN Charter and that of the Arab League, and under the custom Iraq and Kuwait had established of living in peace as sovereign states. Beyond treaty or custom, the invasion violated international law because of the general principle that one state may not overrun its neighbor's territory and annex it by force. Of course, a state may still think it can get away with such a violation of international law. The fourth source of international law, recognized by the World Court as subsidiary to the others, is legal scholarship, the written arguments of judges and lawyers around the world on the issues in question. Only the writings of the most highly qualified and respected legal figures can be taken into account, and then only to resolve points not resolved by the first 3 sources of international law. Often international law lags behind changes in norms. Law is quite tradition-bound. Certain activities such as espionage are technically illegal but are so widely condoned that they cannot be said to violate international norms. Other activities are still legal but have come to be frowned upon and seen as abnormal. For example, China's shooting of student demonstrators in 1989 violated international norms but not international law. Enforcement of international law. Although these sources of international law distinguish it from national law, an even greater difference exists as to the enforcement of the two types of law. International law is much more difficult to enforce. There is no world police force. Enforcement of international law depends on the power of states themselves, individually or collectively, to punish transgressors. Enforcement of international law depends heavily on the reciprocity principle. States follow international law most of the time because they want other states to do so. The reason neither side in World War II used chemical weapons was not that anyone could enforce the treaty banning use of such weapons. It was that the other side would probably respond by using chemical weapons, too, and the costs would be high to both sides. International law recognizes in certain circumstances the legitimacy of reprisals. Actions that would have been illegal under international law may sometimes be legal if taken in response to the illegal actions of another state. A state that breaks international law may face a collective response by a group of states, such as the imposition of sanctions agreements among other states to stop trading with the violator, or to stop some particular commodity trade, most often military goods, as punishment for its violation. Over time, a sanctioned state can become a pariah in the community of nations, cut off from normal relations with others. This is very costly in today's world, in which economic well-being everywhere depends on trade and economic exchange in world markets. Libya suffered for decades from its isolated status in the international community, and decided in 2003 to make a clean break and regain normal status. Libya admitted responsibility for past terrorism, began to compensate victims, and agreed to disclose and dismantle its nuclear, chemical, and biological weapons programs. Even the world's superpower constrains its behavior, at least some of the time, to adhere to the international law. For example, in late 2002, a North Korean freighter was caught en route to Yemen with a hidden load of 15 Scud missiles. The United States, fighting the war on terrorism, had an evident national interest in preventing such proliferation, and had the power to prevent it. But when U.S. government lawyers determined that the shipment did not violate international law, the United States backed off and let the delivery continue. International law enforcement through reciprocity and collective response has one great weakness: it depends entirely on national power. Reciprocity works only if the aggrieved state has the power to inflict costs on the violator. Collective response works only if the collective cares enough about an issue to respond. Thus, it is relatively easy to cheat on small issues or to get away with major violations if one has enough power. If international law extends only as far as power reaches, what good is it? The answer lies in the uncertainties of power. Without common expectations regarding the rules of the game and adherence to those rules most of the time by most actors, power alone would create great instability in the anarchic international system. International law, even without perfect enforcement, creates expectations about what constitutes legal behavior by states. Because violations or divergences from those expectations stand out, it is easier to identify and punish states that deviate from accepted rules. When states agree to the rules by signing treaties, such as the UN Charter, violations become more visible and clearly illegitimate. In most cases, although power continues to reside in states, international law establishes workable rules for those states to follow. The resulting stability is so beneficial that usually the costs of breaking the rules outweigh the short-term benefits that could be gained from such violations. The World Court. As international law has developed, a general world legal framework in which states can pursue grievances against each other has begun to take shape. The rudiments of such a system now exist in the World Court, formerly called the International Court of Justice, although its jurisdiction is limited and its caseload light. The World Court is a branch of the UN. Only states, not individuals or businesses, can sue or be sued in the World Court. When a state has a grievance against another, it can take the case to the World Court for an impartial hearing. The Security Council or General Assembly may also request advisory court opinions on matters of international law. For example, the 2010 court ruling declaring Kosovo's declaration of independence legal was an advisory opinion requested by the General Assembly. The World Court is a panel of 15 judges elected for 9-year terms, 5 judges every 3 years, by a majority of both the Security Council and General Assembly. The court meets in The Hague, the Netherlands. It is customary for permanent members of the Security Council to have one of their nationals as a judge at all times. Ad hoc judges may be added to the 15 if a party to a case does not already have one of its nationals as a judge. The great weakness of the World Court is that states have not agreed in a comprehensive way to subject themselves to its jurisdiction or obey its decisions. Almost all states have signed the treaty creating the court, but only about a third have signed the optional clause in the treaty agreeing to give the court jurisdiction in certain cases, and even many of those signatories have added their own stipulations reserving their rights and limiting the degree to which the court can infringe on national sovereignty. Colombia withdrew in 2012 after the court awarded disputed territorial waters to Nicaragua. Similarly, Iran refused to acknowledge the jurisdiction of the court when sued by the United States in 1979 over its seizure of the U.S. Embassy in Iran. In such a case, the court may hear the case anyway and usually rules in favor of the participating side but has no means to enforce the ruling. Justice can also move slowly. In 2007, the court issued a ruling against Bosnia's case accusing Serbia of genocide, after 14 years of preliminary maneuvering. In one of its most notable successes, the World Court in 1992 settled a complex border dispute between El Salvador and Honduras dating from 1861. In 2002, the World Court settled a long-standing and sometimes violent dispute over an oil-rich peninsula on the Cameroon-Nigeria border. It gave ownership to Cameroon, and Nigeria, which is more powerful, pulled troops out in 2006. A main use of the World Court now is to arbitrate issues of secondary importance between countries with friendly relations overall. The United States has settled commercial disputes with Canada and with Italy through the court. Because security interests are not at stake, and because the overall friendly relations are more important than the particular issue, states have been willing to submit to the court's jurisdiction. In 2004, the court ordered the United States to review death sentences of Mexican nationals to see if their lack of access to Mexican officials had harmed their legal case. Under the 1963 Vienna Convention on Consular Relations, citizens arrested in a foreign country must be advised of their right to meet with their home country's representatives. The United States of America had often failed to do so despite demanding this right for Americans abroad. The World Court suggested that U.S. courts add relevant language to the Miranda warning for cases when police arrest foreign nationals. One of the court's recent cases, a dispute between Argentina and Uruguay, wherein judgment was made in favor of Uruguay and considered it Uruguay's right to have pulp mills on their territory. Because of the difficulty of winning enforceable agreements on major conflicts through the World Court, states have used the court infrequently over the years, a dozen or fewer cases per year, about 140 judgments and advisory opinions since 1947. International cases in national courts. Most legal cases concerning international matters, whether brought by governments or by private individuals or companies, remain entirely within the legal systems of one or more states. National courts hear cases brought under national laws and can enforce judgments by collecting damages in civil suits or imposing punishments in criminal ones. A party with a dispute that crosses national boundaries gains several advantages by pursuing the matter through the national courts of one or more of the relevant states, rather than through international channels. First, judgments are enforceable. The party that wins a lawsuit in a national court can collect from the other party's assets within the state. Second, individuals and companies can pursue legal complaints through national courts, as can subnational governmental bodies, whereas in most areas of international law, states must themselves bring suits on behalf of their citizens. In truth, even national governments pursue most of their legal actions against each other through national courts. Third, there is often a choice of more than one state within which a case could legally be heard. One can pick the legal system most favorable to one's case. Each state's court system must decide whether it has jurisdiction in a case, the right to hear it, and courts tend to extend their own authority with a broad interpretation. Traditionally, a national court may hear cases concerning any activity on its national territory, any actions of its own citizens anywhere in the world, and actions taken toward its citizens elsewhere in the world. Non-citizens can use the national courts to enforce damages against citizens, because the national court has authority to impose fines and, if necessary, to seize bank accounts and property. The United States is a favorite jurisdiction within which to bring cases for two reasons. First, U.S. juries have a reputation for awarding bigger settlements in lawsuits than juries elsewhere in the world, if only because the United States is a rich country. Second, because many people and governments do business in the United States, it is often possible to collect damages awarded by a U.S. court. For these reasons, U.S. courts in recent years have ruled on human rights cases brought by Chinese dissidents over the 1989 Tiananmen massacre, Cuban exiles against the Cuban government, and a Paraguayan doctor suing a Paraguayan police official for torturing the doctor's son. In 2003, U.S. courts ordered large payments by Iraq and Iran to U.S. victims of terrorism and torture. The Alien Tort Claims Act of 1789 gives federal courts jurisdiction over civil lawsuits against foreigners for violation of the law of nations. Human rights activists have used the law against repressive governments in recent years, as when they sued U.S. oil companies ExxonMobil and Unocal for aiding abusive regimes in Indonesia and Burma, respectively. But in 2013 the U.S. Supreme Court sharply limited this extension of U.S. legal jurisdiction, throwing out a case against the Dutch company Shell for facilitating government atrocities in Nigeria. Belgium's national courts are a favorite venue for international human rights cases because a 1993 law gives them jurisdiction over any violation of the Geneva Conventions. In 2001, 4 people accused of war crimes in Rwanda in 1994 were sent to prison by a Belgian jury. Rwanda is a former Belgian colony, and 10 Belgian soldiers had been killed in the genocide there. In 2005, Belgium indicted a former leader of Chad accused of 40,000 political murders in Chad in the 1980s, and Senegal, where he lived, asked the African Union to rule on whether it should extradite him. The encouraged Senegal to try him domestically instead. There are important limits to the use of national courts to resolve international disputes, however. Most important is that the authority of national courts stops at the state's borders, where sovereignty ends. A court in Zambia cannot compel a resident of Thailand to come and testify, it cannot authorize the seizure of a British bank account to pay damages, it cannot arrest a criminal suspect, Zambian or foreigner, except on Zambian soil. To take such actions beyond national borders, states must persuade other states to cooperate. In 2012, a U.S. hedge fund that had lost $370 million in Argentina's 2002 debt default convinced Ghana to seize a visiting Argentinian ship to pay the debt, but Ghana released the ship after a ruling by a UN maritime tribunal. To bring a person outside a state's territory to trial, the state's government must ask a second government to arrest the person on the second state's territory and hand him or her over for trial. Called extradition, this is a matter of international law because it is a legal treaty arrangement between states. Hundreds of such treaties exist, many dating back hundreds of years. If no such treaty exists, the individual generally remains immune from a state's courts by staying off its territory. Some U.S. allies do not usually extradite to the United States suspects who would face the death penalty. The war on terrorism since 2001, however, has expanded international legal and law enforcement cooperation. In one high-profile debate about extradition, the former Chilean military dictator Augusto Pinochet was arrested in England in 1999 on a Spanish warrant, based on crimes committed against Spanish citizens in Chile during Pinochet's rule. His supporters claimed that he should have immunity for acts taken as head of state, but because he was not an accredited diplomat in England where he had gone for medical treatment and no longer head of state, the British courts held him on Spain's request to extradite him. However, the British government eventually let him return to Chile, citing his medical condition, and a Chilean court suspended his case on health grounds. He died in 2006 without standing trial. Gray areas exist in the jurisdiction of national courts over foreigners. If a government can lure a suspect onto the high seas, it can nab the person without violating another country's territoriality. More troublesome are cases in which a government obtains a foreign citizen from a foreign country for trial without going through extradition procedures. In a famous case in the 1980s, a Mexican doctor was wanted by U.S. authorities for allegedly participating in the torture and murder of a U.S. drug agent in Mexico. The U.S. government paid a group of bounty hunters to kidnap the doctor and carry him forcibly across the border, and deliver him to the custody of U.S. courts. The U.S. Supreme Court gave the U.S. courts jurisdiction in the case, showing the tendency to extend state sovereignty wherever possible, although international lawyers and Mexican officials objected strongly. The U.S. government had to reassure the Mexican government that it would not kidnap Mexican citizens nor trial in the United States in the future. The doctor returned home after the case was thrown out for lack of evidence. In late 2004, Colombia arranged the abduction of a leading Colombian rebel living in Venezuela, provoking Venezuelan protests about the violation of sovereignty. The principle of territoriality also governs immigration law. When people cross a border into a new country, the decision about whether they can remain there, and under what conditions, is up to the new state. The state of origin cannot compel their return. National laws establish conditions for foreigners to travel and visit on a state's territory, to work there, and sometimes to become citizens. Naturalization. Many other legal issues are raised by people traveling or living outside their own country: passports and visas, babies born in foreign countries, marriages to foreign nationals, bank accounts, businesses, taxes, and so forth. Practices vary from country to country, but the general principle is that national laws prevail on the territory of a state. Despite the continued importance of national court systems in international legal affairs and the lack of enforcement powers of the World Court, it would be wrong to conclude that state sovereignty is supreme and international law impotent. Rather, a balance of sovereignty and law exists in international interactions. Law and sovereignty. The remainder of this chapter discusses particular areas of international law, from the most firmly rooted and widely respected to newer and less established areas. In each area, the influence of law and norms runs counter to the unimpeded exercise of state sovereignty. This struggle becomes more intense as one moves from long-standing traditions of diplomatic law to recent norms governing human rights. Laws of diplomacy. The bedrock of international law is respect for the rights of diplomats. The standards of behavior in this area are spelled out in detail, applied universally, and taken very seriously. The ability to conduct diplomacy is necessary for all other kinds of relations among states, except perhaps all-out war. Since the rise of the international system half centuries ago, it has been considered unjustifiable to harm an emissary sent from another state as a means of influencing the other state. Such a norm has not always existed. It is natural in some ways to kill the messenger who brings an unpleasant message, or to use another state's official as a hostage or bargaining chip. But today, this kind of behavior is universally condemned, though it still happens from time to time. The status of embassies and of an ambassador as an official state representative is explicitly defined in the process of diplomatic recognition. Diplomats are accredited to each other's governments, they present credentials, and thereafter the individuals so defined enjoy certain rights and protections as foreign diplomats in the host country. Diplomats have the right to occupy an embassy in a host country, within which the host country's laws may not be enforced without the consent of the embassy's country. For this reason, embassies occasionally shelter dissidents who take refuge there from their own governments. A flagrant violation of the sanctity of embassies occurred in Iran after Islamic revolutionaries took power in 1979. Iranian students seized and occupied the U.S. Embassy compound, holding the U.S. diplomats hostage for more than a year. The Iranian government did not directly commit this act but did condone it and did refuse to force the students out of the embassy. Host countries are expected, if necessary, to use force against their own citizens to protect a foreign embassy. Diplomats enjoy diplomatic immunity even when they leave the embassy grounds. The right to travel varies from one country to another. Diplomats may be restricted to one city or free to roam about the countryside. Alone among all foreign nationals, diplomats are beyond enforcement of the host country's national courts. If they commit crimes, from jaywalking to murder, they may be shielded from arrest. All the host country can do is take away a diplomat's accreditation and expel the person from the host country. However, strong countries sometimes pressure weaker ones to lift immunity so that a diplomat may face trial for a crime. This happened twice in 1997, for example, when the United States and France were allowed to prosecute diplomats from Georgia and Zaire, respectively, for reckless driving that killed children. U.S. commitments as host country to the UN include extending diplomatic immunity to the diplomats accredited to the UN. Given this immunity, delegates simply tear up thousands of parking tickets each year, for example. It is estimated that the city of New York is owed $18 million in unpaid tickets. The parking ticket issue has become a sensitive political issue, as the State Department now reserves the right to revoke driver's licenses, license plates, and even reduce foreign aid based on outstanding parking tickets. Similarly, in London 3 cars driven by Sudanese diplomats received over 800 tickets tallying over $100,000 in fines. Because of diplomatic immunity, espionage activities are commonly conducted through the diplomatic corps, out of an embassy. Spies are often posted to low-level positions in embassies, such as cultural attaché, press liaison, or military attaché. If the host country catches them spying, it cannot prosecute them, so it merely expels them. Diplomatic norms, though not law, call for politeness when expelling spies. The standard reason given is, for activities not consistent with his or her diplomatic status. If a spy operates under cover of being a businessperson or tourist, then no immunity applies, the person can be arrested and prosecuted under the host country's laws. Such was the case in 2010, when the U.S. government arrested 10 Russian spies who were leading lives as ordinary citizens in America. Before the prosecution of the accused spies could proceed in New York courts, however, the United States and Russia agreed to an exchange of accused spies. A diplomatic pouch is a package sent between an embassy and its home country. As the name implies, it started out historically as a small and occasional shipment, but today a large and steady volume of such shipments travel all over the world. Diplomatic pouches. 2. Enjoy the status of home country territoriality. They cannot be opened, searched, or confiscated by a host country. Although we do not know how much mischief goes on in diplomatic pouches because they are secret, it is safe to assume that illicit goods such as guns and drugs regularly find their way across borders in diplomatic pouches. To break diplomatic relations means to withdraw one's diplomats from a state and expel that state's diplomats from one's own state. This tactic is used to show displeasure with another government. It is a refusal to do business as usual. When a revolutionary government comes into power, some countries may withdraw recognition. And when small states recognize Taiwan diplomatically, China withdraws recognition of them. When two countries lack diplomatic relations, they often do business through a third country willing to represent a country's interests formally through its own embassy. This is called an interest section in the third country's embassy. Thus, the practical needs of diplomacy can overcome a formal lack of relations between states. For instance, U.S. interests are represented by the Swiss Embassy in Cuba, and Cuban interests are represented by the Swiss Embassy in the United States. In practice, these interest sections are located in the former U.S. and Cuban embassies and staffed with U.S. and Cuban diplomats. States register lower levels of displeasure by recalling their ambassadors home for some period of time. Diplomatic norms call for a trip home, for consultations, even when everyone knows the purpose is to signal annoyance. Milder still is the expression of displeasure by a formal complaint. Usually the complaining government does so in its own capital city, to the other's ambassador. The law of diplomacy is repeatedly violated in one context: terrorism, CPP. 204-209. Because states care so much about the sanctity of diplomats, the diplomats make a tempting target for terrorists, and because terrorist groups do not enjoy the benefits of diplomatic law, as states do, they are willing to break diplomatic norms and laws. An attack on diplomats or embassies is an attack on the territory of the state itself, yet can be carried out far from the state's home territory. Many diplomats have been killed in recent decades. In 1998, al-Qaeda terrorists bombed the U.S. embassies in Kenya and Tanzania, killing more than 200 people. In late 2004, terrorists stormed a U.S. consulate in Saudi Arabia, killing several guards, and in 2012, they burned the U.S. consulate in Benghazi, Libya, killing the ambassador. Just war doctrine. After the law of diplomacy, international law regarding war is one of the most developed areas of international law. Laws concerning war are divided into two areas: laws of war, when war is permissible, and laws in war, how wars are fought. To begin with the laws of war, international law distinguishes just wars, which are legal, from wars of aggression, which are illegal. We discuss laws in war later in the context of human rights. This area of law grows out of centuries-old religious writings about just wars, which once could be enforced by threats to excommunicate individuals from the church. Today, the legality of war is defined by the UN Charter, which outlaws aggression. Above and beyond its legal standing, just war doctrine has become a strong international norm, not one that all states follow but an important part of the modern intellectual tradition governing matters of war and peace that evolved in Europe.